The following paid program is sponsored by the Law Office of Selwyn Whitehead, who is solely responsible for its content.
This is Selwyn's Law. Every week at this time, we get to hear from Selwyn Whitehead. She's not just an attorney at law. Selwyn knows her stuff and doesn't shy away from the truth, even when it's ugly. Her Bay Area practice focuses on helping her clients to manage their wealth through estate and tax planning, to managing their debt through reconstruction or bankruptcy. And now it's time for Selwyn's Law.
Welcome to Selwyn's Law with award-winning bankruptcy attorney Selwyn Whitehead. Hi, Selwyn.
Hi, Clifford. How are you?
I'm good. I'm very, very good getting ready for this Thanksgiving coming up. And hopefully I don't overeat yet again. I thought today, though, we talk about something that is very, very important, and yet people at times don't really want to talk about, and that's estate planning. Can you give us your take on what we need to do, why, and maybe just a general overview?
Well, sure. And, it's very timely because I have a pretty big birthday coming up. And last week in the mail, I got this notice from the Department of Motor Vehicles telling me that, I couldn't just send my money in. I had to actually come in. Because I guess that old picture of me, and they know that I'm going to be of a certain age, as like many of us are. And it's just a good time to think about, what do you want to do with your assets? Who do you want to have them? And how do you go through the transition of putting your assets into something that you are in control of while you're alive, and you can spend the rest of your days enjoying life with the knowledge that you've taken care of this very important piece of homework? So if in the way I look at it, estate planning has two separate and distinct components and goals, and really depends on the phase of life one is in and who my client is and what it is that my client ultimately wants to do.
Okay.
So the first goal during the plan development phase, my client is typically an individual or couple who want a well-thought-out plan for the ultimate disposition of their assets. But they also want a vehicle that they can put their assets in right now to protect them, and also provide a mechanism for proper treatment of themselves and their minor dependents, if they have any, when they're no longer able to take care of themselves or their minor dependents because of, ultimate death or, even worse, interim disability. As such, estate planning, the process focuses on giving my living clients peace of mind. At the end of the day, clients purchase estate planning services from attorneys because they want the peace of mind that comes with the knowledge that their affairs have been put in order, thereby freeing the client up to focus on finding and achieving their true reason for being on this planet, to serve God, how they see God, and living a fulfilled, joyful life. And then there's a second phase, what's known as the post-mortem plan settlement phase. So in that case, my client will either be the successor trustee if the assets were put into one or more trusts by the original trustee or trustees, or my client might be the executor of a probate estate if the deceased had no trust, or in other situations, if there's a problem with the settlement of the estate, my client could be an unhappy trust beneficiary or a probate heir or a creditor of the deceased or some other interested party, such as an unhappy boyfriend or girlfriend of the deceased who was purposefully or inadvertently left out of the estate. So in each of these scenarios, the postpartum settlement process should focus on minimizing or eliminating the deceased client's obligation for income taxes, estate taxes, gift taxes, generation skipping taxes, and increasing or at least preserving the value of the estate during the trust administration process, which could go on for many months or even years, and thereby making sure that the known wishes of the deceased are carried out according to the laws here in California. So speaking of laws, what laws come into play when you're dealing with estate planning? Well, there's the Internal Revenue Code, federal laws, and that's because there are many tax-related issues involved in both the planning stage and the implementation phase of an estate plan. People don't realize this, but there might be a huge estate there, but the first people to get part of that estate is the Internal Revenue Service and or the Franchise Tax Board. And that's because there are things called estate taxes or transfer taxes for gifts that are made. And so you actually have to file a last tax return for the deceased. And you could do a short year election, meaning, say, like if someone dies on October 31st of this year, the tax return would be for a short year, would be from the January 1 through October 31st of 2014. And then the rest of the year, so that tax return would be for the deceased person in their name. Then their trust, their estate comes into play upon their death, and tax returns have to be done for the estate. That's so that the Internal Revenue Service can make sure it gets its piece of the action. That's just the way it is. But if during that estate planning phase, the attorney that was working with the deceased did things properly, hopefully the taxes that and some taxes will have to be paid, but the idea is to minimize those taxes so there's more left of the decedent's estate to go to his or her chosen beneficiaries. So there's the Internal Revenue Code, and then there's the California Revenue and Tax Code, and that's because there might be some outstanding income taxes or property taxes that need to be reported and taken care of. So the taxing authorities, they get theirs first, and they make sure that whoever's handling the estate files the proper tax returns and does the appropriate reporting. Also, the California Probate Code and cases come into play. Those are state laws, and that's because the probate code here in California is applicable even if the deceased chose a airtight trust, because the laws concerning deceased are in the probate code, and a probate is the process where one would go through the court. If one didn't have a trust, one would have a will. A trust, the court would actually supervise the disposition of the estate. And another group of laws that are involved is the California Corporation Codes and cases, and that's in case the deceased had a business that wasn't a sole proprietorship. So let's talk about the estate planning tools. There's a will. Let's talk about that first. A will is a legal document, and it's drafted and executed in accordance with state law. It becomes irrevocable at your death. And in your will, you name your beneficiaries. Those are your family members, friends, domestic partners, charitable organizations who will receive your assets according to your directions. You can leave specific gifts to individuals or entities, or general gifts. Specific gift, I leave my diamond brooch to my lovely niece, Selwyn. That's a specific gift. A general gift would be I leave 20% of my estate to my favorite grandchild. And a will, you can also select the guardian for your minor children. You can nominate a person who will have responsibility for the care of your child or children if you and your spouse die before your child reaches the age of majority. Here in California, that's 18. And you'll also have an executor. That's the person or institution that you choose and you name in your will, and they must be appointed by the probate court. But their task is similar to that of a trustee in a trust, and that is to say they collect and manage your assets, pay your debts and expenses, including your taxes, and then in a manner approved by the probate court, a judge, they distribute your assets to your beneficiaries according to the provisions of your will. Your executor plays a very important role and has significant responsibility, so you need to, it's a time-consuming job, at least initially. So you need to find someone that you believe will do the job, because there are liabilities involved if they don't carry out their role. This person would be a fiduciary, meaning that they would have to treat your estate and give it more care and attention than they would give to their own property. So that's what a fiduciary is. So in a will, the fiduciary is the executor of your estate. But say you have a trust. A trust is a written agreement between the individual or a married couple creating a trust and the person or institution's name to manage the trust. In many cases, it's appropriate for the creator or grantor or settler, that's the living person who is creating the trust, to be the initial trustee of the living trust, and thereby have the ability to manage his or her or their own affairs with the knowledge that at some point when they become unable via disability or ultimate their demise, that the the trustee that they've selected will be able to carry on and fulfill their wishes. Now, the terms of trust become irrevocable upon the death of the trustor. Because the trust contains provisions which provide for the distribution of assets at the grantor's death, the trust is a substitute for a will and may or may not eliminate the need for a probate of the deceased's will. So I don't want to confuse people here. Some people out there have been advertising that if you have a trust, you never have to go through probate. End of story, period. Well, I'll give you 2 examples of why you might want to at least have part of the trust go through probate. When you go through probate, there is a cutoff for your creditors to file claims. It's 4 months. If you don't go through probate and you inadvertently or intentionally leave a creditor out, and say you've gone through the process of administering the trust, you've distributed all of the assets according to the trust documents, but you left off this creditor, and that creditor had no knowledge of your demise. And say you're a doctor and you might have performed surgery on this individual, and sometime after your death, they found that sponge that you left in there, and now there's a malpractice claim that's going to arise, and they might be able to pull the assets back from your beneficiaries if the late doctor's patient sues the estate. So it might be appropriate to utilize the probate process of notifying everybody and cutting off the statute of limitations for claims to be filed, sort of like bankruptcy. And that is one reason why you might want to use probate even though you have a trust. And another thing is, if you're outside of probate, say the trustee wants to do something that's a little bit extraordinary or out of the norm, you might want to run that past the judge and get the judge to stamp off on it, with the idea that you don't want one of the beneficiaries later coming back and saying that you breached the fiduciary duty with me by doing making that extraordinary investment. And so, I know we're running out of time, but this is so exciting to me. So I really enjoy talking about this. And so there's parallels. The reason why I picked up on this, or maybe some people say I picked up on bankruptcy, is because to me there's some of the same concepts involved. Preservation of the assets, doing what's right by the beneficiaries, doing what's right by creditors, having a fiduciary in charge of all this. Part of it's done while the estate is going. Part of it's done when the person is dead. So why don't we pick up on trust when we come back?
Okay, I like that idea. There's just so much more to this than I ever would have imagined.
It's more than a notion.
Yes, fascinating stuff. Selwyn, so since there is so much and it is so involved, if someone has questions, maybe wants to work with someone to help plan their estate, how do they get in touch with you?
They can give me a call at area code 510-633-1276, or they can email me. My email address is my name, selwynwhitehead@yahoo.com. And you can also reach me at selwyn@selwynwhitehead.com.
Oh, I like that one. That's so easy, even I can remember it. Selwyn, thank you so much. Fascinating things this afternoon. And thank you for taking time to listen to Selwyn's Law. Remember, the Law Office of Selwyn Whitehead is a designated debt relief agency under the federal law and provides legal assistance to consumers seeking relief under the Bankruptcy Code. When it comes to your finances and your rights, seek no other than the Law Office of Selwyn Whitehead. Selwyn is your go-to finance attorney, specializing in estate planning, wealth management, bankruptcy, tax, and real estate law. In other words, Selwyn knows her way around the dollar, and your rights are protected by our laws. Protect your money, know your rights. Partner with Selwyn Whitehead. For immediate assistance, or if you have questions, call 510-633-1276, 510-633-1276, and go to selwynwhitehead.com.